One difference was taken out. I was going to say you have her notes, right?
Say what?
You have her notes, right? Or a little intro thing.
I don't have a great deal to say about it.
That's all that was what I had jotted down. If that's helpful. Wasn't quite sure if we just said, here's the judge or something. Okay.
We're on, yeah, it's 1 o'clock, we are on, so. I mean, guys,
All right.
but we need to do a set, should I come back to this?
So we call the meeting to order. You need a break? Oh, huh?
He was just gonna go get him.
You're gonna go get our next.
You need to make sure you do a motion to come back out.
Okay, well, I move that we come out of executive session and we get back to our interviewing process.
Is there a second to that motion?
Second.
All those in favor?
Aye.
Opposed? All right, we are back in session. Somebody must have turned them on. Good afternoon.
Good afternoon.
The commission, I'd like to introduce to you the Honorable Cheryl Rios. Judge here in Shawnee County. She has been on the bill since 2008.
Thank you.
Welcome, Judge Rios.
Thank you.
You have the hot seat.
I do.
Yes.
Thank you for the opportunity.
Do you want to start? Go ahead. Okay. Judge Reese, I have a really kind of a brief question for you, but it's my understanding that you've been through this whole process before.
I sure have.
So I'm curious, what was the question that you did not get asked during your last interview that you wish you would have been asked? Or
That's a very good
what
question.
what do we need to know about you that we may have?
Well, I think that I will tell you probably what I didn't answer. Maybe, I don't know if you asked it, but since 2020, when I first applied, I've had an incredibly greater amount of court administrative experience through committee work that I've done, either through the Kansas District Judges Association, through the, more recently, the statewide Judicial Strategic Planning Committee, working on the Personnel Committee, Judicial Education, just numerous additional experience that I've gained over the last 5 years serving the court.
Thank you. I also understand that in 2019, you were invited to participate in the oral arguments in the Supreme Court. Can you tell us a little bit about that experience, specifically kind of what you learned about that and how that makes you a stronger candidate, if it does?
Well, I had the good opportunity to do that, and I appreciated that. I certainly had a perspective of what the court did and in terms of hearing oral argument and processing cases, but that really gave me firsthand experience. We heard several criminal matters on the docket for that week. We were given the opportunity to review the briefs and conduct our own research. We collaborated with one another over the decisions that would ultimately be filed by the court. So I suppose it gave me the opportunity to see firsthand what it would be like to collaborate in a way that I don't get a chance to do on the district court, and I understand that it's very much a different pace and a different job altogether. So I appreciated that, and I appreciated the opportunity.
Can you just tell us a little bit about the process that you use as a district court judge to analyze a case and prepare an opinion?
Sure. So each day I have a large docket. I manage 140 to 170 cases. So typically I have a deadline for motions that are set on a particular issue. So I'll review those motions before I enter into the courtroom. I conduct my own independent research. I enter the courtroom and call the case. I will hear sometimes through testimony, sometimes through oral arguments or physical evidence, matters that will help to, I guess, narrow the decision-making process. But ultimately, clearly I approach both sides with a fair and open mind. Although I've conducted my own research, it's possible that my mind could be changed once I actually see the facts that come out in those arguments. At times, I may pronounce a decision from the bench. Depends on the complexity of the particular decision and how quickly we need to move with a particular case. But many times, and most times, when I'm dealing with a weightier case, such as an off-grid case, or certainly if there's a death penalty case, which I've handled, or just cases that are a little weightier, I think it's important to have a written decision. The bottom line is, whether it's through written decision or if it's pronounced from the bench, it must be founded in the law, and it must be understandable to the parties. In other words, even though if they don't agree with it, I must at least be able to express how I got to the decision that I made in hearing the facts and applying that to the law.
Thank you. I'm going to turn it over for other questions.
I have a question. How is your district court divided? I know, like, I'm from Wyandotte County, so they divide up, so many of the judges have criminal, civil, juvenile, etc. How is that the process in Topeka, and in what areas have you been a judge?
So when we are selected to serve, whatever is open is where you will reside until there's another opening and an opportunity to move. So once we're in a position, we will remain in that position, and it's really a seniority process. So if someone has been on the bench and they like their particular area that they're serving in, then they can continue to serve in that area. I started out doing what we called the criminal duty judge, wherein I heard all misdemeanors, and I heard all of received all the warrants that came in for the court. I also processed all of the domestic civil protection from abuse, protection from stalking cases in Shawnee County for 2 years. Thereafter, I went into a felony criminal assignment. And those are primarily the assignments, the type of assignments that I've had. Criminal matters, by its nature, often end up, once someone has been convicted, there are a number of civil pleadings that get filed post-conviction. So I handle those civil proceedings as well.
Okay, thank you.
Judge
What-
Rios,
Oh, go ahead.
thank you for being here today.
Thank you.
You've spent a significant portion of your career doing criminal work. And so I wondered if you could tell us a bit about your approach to learning new things and maybe give us an example of a time when you had to get up to speed on an area of the law that you were completely unfamiliar with.
Well, I suppose everything is new when you when you do it for the first time, but I will say that I can recall pretty early in my judicial practice, I was assigned to a death penalty case, and there were no judges sitting at that time who had handled a death penalty case. So I couldn't really reach out to a colleague. What I did was I recall researching almost every death penalty case in the United States for precedent in order to identify the legal issues that I would face pre-trial and trial and post-conviction. I just dove in and learned how to process that case, and then I did it. And ended up resolving in a plea, but not until all of the highly contentious and highly litigated issues of a constitutional matter were litigated. But I felt quite confident in my ability to research and learn all about that and issue sound decisions.
One more question. So as a district court judge, you have the luxury or maybe the responsibility of being autonomous. You make
Mhm.
decisions on your own. Appellate judging requires collaborative decision making, often with colleagues who may see the law differently than you do. Can you describe a time when you had to work with others to reach a difficult decision? Maybe even, when there was disagreement and how you approached reaching consensus or navigating any conflict?
Let me first say that if you've looked at my application, you know that I was a nurse at one time. And so one consistent quality throughout my lifetime has been not only being a critical thinker, but an excellent communicator. And that involves not just speaking, it involves not just listening, but active listening and being willing to hear another person's side to an issue and being able to bend when bending is appropriate for the situation, but also being able to stand firm in a position if necessary. So describe a particular incident where that has happened. I will say that there are numerous. I'm not sure if this one will be on point, but more recently, I have, as president of Kansas District Judges Association, there was a special Supreme Court rule that had been published that a number of our district judges had missed and had not read or made comment upon. And we began to hear it, and it began to filter around the district courts about this particular rule. And judges were not happy about it. So as the president of Kansas District Judges, we approached Justice Lugert as well as OJA, court administrator, and we explained to them what the circumstances were, and we were able to convince them to pull back on the rule and give us an opportunity to share with our membership what the changes were going to be with that particular rule. They gave us an opportunity to collect comment from those judges. We provided that to the court. Now that issue is pending, and the court may very well decide that it's going to stay just as it originally was going to be, but at least we were able to engage in the process and help to move that to a solution that I think at least judges will be satisfied that they had input into the process. is that the kind of example that you were looking for?
I think it's a great.
Okay,
Thank you.
I want to take you back to when you said you sat with the Supreme Court
yes.
and just ask you, what did you learn from that and what surprised you the most in sitting on cases before the Supreme Court?
Well, I don't know that it surprised me the most, but it was something that I had not ever experienced,
Mm.
which is to collaborate with fellow justices and talk about what we had just heard and the law that would apply to it, and identify, first of all, who was going to write the opinion and whether or not everyone else would fall in sync with that opinion. Just that particular process of, I understood that the court collaborated and spoke together, but I had just never actually experienced it, having been pretty independent, as I said before. So I would say that is probably the most surprising to me, was just the experience of it.
Okay. And do you feel after experiencing it that that's something that you could work with, and do you feel you're strong in collaboration or could be?
Absolutely, absolutely. And, I have spoken with a number of justices over the years. As indicated previously, I applied in 2020 and I spoke to justices back then, and I've spoke to them now. So I believe I understand the differences of coming from a trial bench to coming to the Supreme Court. And I believe that I will be able to communicate and collaborate with other justices about pending issues. And if I need to bend, I will bend. But if in situations where I just can't agree that the law is such that the others believe, that it's incumbent upon me to write a dissenting opinion. And I would be willing to do that if I need to do that.
Judge Rios, I've received, nice to meet you. Lots of information from Kansans across the state talking about your temperament, having compassion, integrity, and wanting to serve the people in the state.
Right.
To this end, can you talk or share with us a little bit about your community work and what you do to help educate the public about the judiciary?
Okay, that's a big question.
Yes.
That's a very big question. So let me say that I grew up in a small Mexican-American community 10 minutes from here. My mother, the people that I went to school with, we went to a segregated school. The people that I went to school with were from hardworking, blue-collar families. My mother was one of 12. I was one of 6. So first of all, as soon as we were physically able to help, we did. And not just in our homes, but in our community. Every year from the time I was born, it actually goes back to my grandfather. Every year, our whole community would take off work for a week in order to put on one of the largest Mexican fiestas in our community. That was actually a regional community. So we did that because we needed to keep our schools open. And slaving away in the kitchen over washing dishes or over a hot stove or serving in a booth, or those things at the time, it didn't feel like work. It was a lot of fun. We were around our friends, our family, our community, and it felt good. And I think I have taken that with me throughout my life. I have always been a part of something that's bigger than myself. Whether it's all of those things that you've seen, all of the volunteer opportunities that I've had. And I say they're opportunities because it's still an opportunity to be able to volunteer. And why is that important to the court? At the court, at its very core, our court is about serving people. And having an understanding of who the people are is critical, because having served in those underserved areas of our population, I understand the institutional barriers that prohibit people from coming to court and having access to justice. You know, I think as you well know, there's 3 co-equal branches of government. And the judiciary is responsible for interpreting the laws. But if our public doesn't have access to that, to find redress or solutions to problems that they can't solve anywhere else in their community, then we don't have a democratic society. It's civil unrest. So that's a multifaceted question. So I could probably talk a lot more about the importance of the public's understanding of our jobs and access to justice, and just the public having trust in our courts as well.
Thank you.
Okay.
I've got a few questions. Yeah, all my compatriots here are getting used to me, I think. So on your legal experience, there's private legal experience and there's public service. And you've got a great resume with public service, and you've been on the bench. So that's all helpful. Is there any, have you had any private legal practice experience since you graduated from law school? And if not, that doesn't mean that it's a disqualifier or anything. It just means how have you kind of learned what it's like to be a private lawyer that shows up before you in court in a way?
Well, I haven't had a lot of private practice experience, and I think that my resume demonstrates that. I have had a lot of experience. I tend to keep an open mind, and I understand that. I don't know whether it's through experience or time that has allowed me to have a deep respect for what it takes for attorneys to prepare their cases. When I have attorneys, so don't be fooled that I haven't had civil litigation. I've had incredibly complex criminal matters in my courtroom. So, you know, when an attorney walks in with 3 dozen banker boxes of work, and they're organized to the T, I know how hard they've been working to be prepared for me in court. So while I haven't had private practice experience, I do believe I can understand what the approach that they have to take in order to come in and make their arguments that day.
Yeah.
Is that
Yeah.
helpful?
Yeah. I mean, it's not a disqualifier not to have
Yeah.
everything. I mean, some people are not going to have any government service, or some people are not going to be district court judges and they won't have that experience. So it's just another factor. One of the things that stood out for me when I looked at your application was that you were a graduate of St. Mary of the Plains College. And I'm from Dodge City, so I know all about that.
Okay.
But congratulations on that. Character and ethics is one of the qualifications for us to consider for the applicants for the position on the Kansas Supreme Court. Tell me about, you've told us a little bit about where your character would come from your upbringing, from the town you grew up in, and from the people around you. So could you elaborate on that and how that's molded your character and your ethics about truth and justice and the like, which you'll deal with as a Supreme Court justice?
Sure. I'm going to fall back to my family, and you know, my grandmother raised 12 kids in a 2-bedroom home. Yeah, at 14, 15, 16, they had to go out and work. My family, my mother, everyone has had an incredibly hard work ethic. And so first and foremost, I have that. And I think I learned early on that if you don't have integrity, and let me just say, integrity to me is doing the hard thing when nobody else wants, or doing the right thing when it's hard and when maybe nobody else wants you to do it. And that's ongoing. That's an ongoing issue because we face hard things all the time, and we battle with those things all the time. But I would like to think and hope to think that I land on the right side, primarily because it's the right thing to do. And I feel that my work, my personal life, my professional life has all demonstrated my ability to be fair to people. Have I answered your question?
Yeah.
I feel like that was,
I mean, that's a hard question really to articulate in a lot of ways. So let me ask you one other thing here. Of all the things that you've done in your legal career, what would you think, would you believe or would tell us that would be the most significant and the most rewarding thing that you've ever done?
mm,
Either to you or the people that were impacted by what you did?
well, there's a few things. Clearly there's always going to be 50% of the people that are not pleased with decisions that you make. So when a lawyer comes back to me and I've ruled against them and they tell me I did a good job, even though they didn't win their particular argument, they appreciated what I did, how I treated them, and how clearly I expressed the route that I took to get to the answer that I got. So that means a lot to me. I've had defendants come back to me years later and say, and sometimes in public, and say, Judge Rios, I am so and so. I just want to thank you because you gave me a chance, and I want you to know that I've been drug free for X many years. And that's rare. That's very rare, but that's also rewarding because it's hard to know when someone is going to make it or not make it. Those are a couple of examples.
Thank you. Thank you very much.
Thank you.
One more. Judge Rios, what do you think is the single most important trait or characteristic of a Supreme Court justice?
One trait.
Have to pick one.
Just one. That's a challenge. I would say that they need to have integrity.
And how do you measure up?
I think I have integrity. I think I would be able to do the right thing even when it's hard.
Thank you.
Your Honor, we've got 15 very qualified people
Mm.
who are being considered for the slot of 3.
Mhm.
Do you have a sense of what separates you from the herd, so to speak?
Well, first of all, I would say that nearly 17 years as a trial judge is significant. It's significant for a couple of reasons. One, and I know having served in the trenches, having been a frontline judicial worker, I understand not only what it takes to make a good record for appeal, and I know what the appellate courts are looking for, but I also understand what it takes to process cases at a district court level. And of course, the Supreme Court is responsible for the administration of justice of all courts in the state. And so having that perspective of how long it takes a clerk to process a particular type of case. And recently we had a situation where the process was, there was a 4-hour rule. for clerks, and with the advent of changes and advances in technology, for some reason, those cases were taking more like 8 hours rather than 4. So that just knowing some of those intricate things that happen around a courthouse are important in order to relay that to the court and to help. So that's one thing is my work in the court. I've already talked a bit about my volunteerism and how that has connected me, I think, to some of the most vulnerable people in our community. Um, I think that my experience as a tribal attorney kind of adds to that. We did serve quite a vulnerable population at Cherokee Nation, and it helped me to better understand the needs of people who don't have access to many things, let alone our courts. I would also say that my experience, I talked about my volunteer experience, but I haven't talked about the fact that in all of the professional experiences and positions that I've had, I've volunteered to do committee work in each of those positions. More recently, I'm currently the president of the Kansas District Judges Association and have worked to represent all judges in the district courts related to matters that affect them or the clerk's office or our courts in Kansas. In addition, I've recently been assigned to work on the statewide Judicial Strategic Planning Committee. I will be attending the Court Technology Committee, where we will learn about the advances of technology for our courts going forward. I've served on statewide education committees. I've served on national committees of, that in order to learn more about how our courts are doing it nationwide. Those are just a few things that I think, I think that sums it up.
Do you view, I won't say lack of experience, but maybe limited experience with regard to Chapter 60, Chapter 61, and Chapter 59 proceedings to be a weakness for you?
I do not. I see it as a challenge, but I don't see it as a weakness. I think that my approach to those types of cases are going to be essentially the same. As I've indicated, I have heard complex cases. I have heard complex off-grid cases that often involve, many people, multiple victims at times, highly contested constitutional issues. Those cases often draw media attention. They're highly stressful. The litigants have high stakes in those outcomes. So I would approach complex civil litigation cases very much like I approach other complex cases, which is that I will do my research, I'll do my homework, I'll approach each case with an open mind and fairly, and my decisions will be founded in the law. I'm not someone that is here to tell you that I know everything, but I certainly am here to tell you that I'm a lifelong learner. I have been, and I think I've demonstrated that. So I don't believe that is a weakness. It's certainly a challenge that can be overcome.
Have you acquired a philosophy with regard to constitutional interpretation?
I have sworn an oath to abide by the Kansas Constitution and the United States Constitution, and I will follow the Constitution. I think that it's the law of the land. People they live their lives by those sets of rules. Clearly, there are times when changes have been made over time by the citizenry who have decided that amendments should be included in those constitutions, in the Constitution. If you're referring to, you know, I believe in a strict reading of the Constitution. If you're asking me how I would apply other laws and case precedent, I would certainly abide by case precedent. And please elaborate a bit more if I'm not answering your question, because I think I'm not.
Right.
Okay. Because I could go a different route, but I want to be sure that I'm answering the question that you want me to answer.
Well, as a follow-up to that question, would your approach to the Kansas Constitution be any different than your approach to the United States Constitution?
No. The United States Constitution is the law of the land. It's overarching the Kansas Constitution. I would have to abide by both.
Thank you very much.
Thank you.
Any other questions? Well, Judge Rios, we appreciate your time. Thank you so much for coming.
Well, thank you all so much for giving me this opportunity.
Yes,
I hope that I answered your questions. Thank you.
thank you.
X marks the spot here.
Yeah,
Yes.
it's hot. It's the hot chair.
He is a graduate of Cornell Law School and had graduated summa cum laude from Oral Roberts University and resides in Topeka. He's had a variety of positions in the legal profession, from a law clerk in the Court of Appeals in South Dakota, special assistant to the Attorney General in the Civil Division, the Department of Justice. Has been with several law firms, and also served as chief counsel for a governor in the state of Kansas, and also worked in the office of the Kansas General. If I missed anything, please fill us in terms of comments. I'll start off with 7 questions. And my first question would be why do you want to serve on Kansas?
Certainly it's something that's been in the back of my mind for quite some time. It's really never worked for me logistically in terms of where I was with my career and so forth. I have a significant interest in appellate law, and we can talk more about that. I've always, of course, I clerked, my very first legal position was as a law clerk to a federal appellate judge. And during the era I was coming up in the Kansas City legal community, there still wasn't a highly developed appellate practice group in most of the big law firms. And since I'd been the law clerk, it was like, oh, we'll have the appellate law clerk do it. So I kind of became the de facto appellate lawyer in the law firms I was in Kansas City. So that kind of explains why the Kansas Supreme Court. I've always had an interest in legal issue development and legal issue spotting. That's the work of an appellate judge. And I think it's important for people of good nature and goodwill and without an axe to grind to step up and serve. And I viewed my move from private practice to the chief counsel role as part of that. Frankly, really enjoyed being involved in public law and continued that as Solicitor General of Kansas. where I had a chance to work with an incredible team of great appellate lawyers and develop and argue some of the most significant cases I think the court has decided in the last few years. So it seemed like a very logical thing to do. And I had finally reached the point in my life where logistically it works with where I am. I concluded my term as Solicitor General in 2023. And it was a good time for me to sort of reassert my involvement in our family business, which is ranching, headquartered in Washington County. My father had passed away in 2018, and we'd had a turnover in our ranch manager in 2021. My mother's 86 and still lives alone at the ranch. And the law and business being what it is, it's amazing how a significant ranching operation needs a lawyer. So I spent a lot of time dealing with mineral leases and hunting leases and rights of way and easements and various negotiations and other business practices at the ranch, as well as representing a few clients, primarily old friends from my government service in private practice. So that's what brings me to the point of having applied for the first time to potentially be a justice on the Kansas Supreme Court.
In general and throughout your professional experience, what would you say were some of your traits when it comes to administrators? So both of those positions did require a significant amount of administrative work in terms of managing and working with the staff. The chief counsel provision for the two governors, it's interesting, we all learn in school, right, that there's a legislative branch, a judicial branch, and an executive branch. And that's very true as to the federal government. In Kansas, the executive branch is actually fractured, right? Because the governor, even though the Constitution says he shall have the supreme executive authority, he doesn't as to insurance. We have an insurance commission. He doesn't as to the state treasurer. And of course, he doesn't entirely as to law and litigation. We have an attorney general who the Kansas statutes say is in charge of all litigation. But that leaves a lot of other things. So as the chief counsel, I actually supervised approximately 100 lawyers that were spread across the cabinet departments of the governor's part of the executive branch. Litigation was always first choice to the attorney general's office. But, staffing and scheduling being what it is, quite often we would take litigation back with the attorney general's agreement, and our lawyers in the cabinet departments would deal with those issues. So that was a significant part of the job, managing the legal functions of the executive branch, human resources, implementation of new statutes. When I first became the chief counsel, one of the things I did was personally visit each of the cabinet agencies. And I met with either the chief counsel or the secretary or both and talked about what was going on in the agency and asked them I asked each of them, what was the one thing I should be most concerned about? What should I have in the back of my mind? What would be something that would happen in this agency that I would have to address and that the governor would want to know about? I will tell a brief story. I'm bad about this. I'm an old litigator. We tell stories. Wonderful gentleman named Lyndon Apple was our counsel at the Department of Prisons. And if you knew Lyndon, he was like 7 feet tall, this big square jaw. He's retired now. And he leaned back in his chair, scratched his throat. How about this? A prison riot. And I was like, yeah, if that happens, give me a call. And by the way, it did happen. We had prisoners setting fires at the El Dorado prison, and I was on the phone with Lyndon and the strike team that immediately dispersed the prisoners. So that's perhaps an extreme example of my involvement in administrative matters. Moving to the Solicitor General, I had a staff of, I believe that were at our peak, there were 5 we sort of individually hired, handpicked. We had a U.S. Supreme Court clerk. We had a 10th Circuit clerk for a 10th Circuit judge who went on to be a U.S. Supreme Court justice. We had a Kansas Supreme Court clerk, and these were really sharp young people. One of the pleasures of my life working with my staff in those positions was
working with young people. They bring new vigor and interest and excitement to me, to the practice of law. And so I would have to assign cases, right? And then work with them on development of their cases. Most of our briefs and most of our most significant cases were collaborative. So quite often one of them would take the first draft and then it would get circulated amongst the entire office. And everyone would make comments, and then the original author would incorporate those comments or tell us why he or she thought they should not be incorporated. But that's just sort of a little window into how I've worked on administrative matters in terms, not the actual practice of law, right? Not actually arguing a case or working on a case, but managing people and all that comes with that.
We have, as you've seen, we have really strong candidates. What do you think makes you stand out above all the others?
I would say there two things come most immediately to mind. The first would be, and it's basically legal experience and diversity. The first would be my legal experience. I suspect, I haven't verified it, I'm not sure if it's possible to verify. I suspect I am the only attorney in the state of Kansas who has argued in 6 of the United States Courts of Appeals. And in addition to that, has the appellate experience in the Kansas appellate courts and elsewhere that I have. In addition to that, I haven't only been an appellate lawyer. I have appeared in, I counted, it was, I think, 56 cases across the United States, or courts, the majority of them being district courts, trial level courts. For most of my practice, I was a litigator, a trial level litigator. Not a lot of the cases went to trial because of the nature of the cases, but I certainly tried cases. So in addition to, for sort of a heavy base of appellate experience, I do have the trial experience as well. Certainly the majority of my cases over the years have been in the area of civil law, but not exclusively. I also have a not insignificant amount of criminal law experience, both from private practice. Interestingly, in the governor's office, I was the pardon attorney. So I read a lot of criminal case records as the pardon attorney for those 2 governors. And of course, as Solicitor General, we had many criminal cases. I argued a criminal case, a death penalty case in the Kansas Supreme Court. All of our criminal cases that went up to the U.S. Supreme Court on cert petitions. The Solicitor General always serves as the lead counsel in the U.S. Supreme Court, and I was lead counsel on all those cases. Cert was not granted in any of them. So I think I have a diversity of legal experience, appellate, trial, civil, criminal. And then I think I have a diversity of life experience. I noticed in the meeting after the applications came out that the chair indicated that, well, all these nominees are from Eastern Kansas. And I am a person who has his other foot, frankly, in rural Kansas. I could just have easily have listed Hanover, Kansas, as my address on this application, as I did Topeka. I still have my Topeka house where I lived full-time while I was chief counsel and solicitor general, and still spend about half my time here in Topeka. But the other half is spent at the ranch and dealing with all the things that you deal with in rural Kansas and rural America. And frankly, among them, kind of some issues that affect the court and legal practice. The depopulation of rural Kansas is, a concern of mine and most of us who live there. And I know the court has been concerned about that as well. Justice Wall has a great initiative to encourage young lawyers to think about practicing in rural Kansas. And certainly the rural attorneys, and I've worked with many of them, are an important part of the culture there. So that would be the second aspect. I think I bring a diversity of life experiences, and then I'm not solely an Eastern Kansas City lawyer, as my rural friends call it. I was a tall building lawyer during my career in Kansas City. But so that's what I believe I have to offer that I think makes me unique in these circumstances.
Thank you.
Just as a point of clarification, in your resume, the last entry is private practice of law / law land. Lao, is it Lao?
Lao rhymes with cow.
Okay, thank you.
which is convenient given.
Give them the ranch.
So my question is, are you actually in private practice or is your sole client the ranch?
It is not my sole client. Like, as I mentioned before, I have not a large number, but I have clients mostly from my time in politics and government. I've formed a couple of 501c3 entities and represent them. And I don't have any active litigation at the moment, thankfully, representing the ranch. So I do have a private practice in addition to my work for the ranch.
And is that here in Topeka or is
It's both. I mean, I mostly do it out of my house here in Topeka.
okay?
You mentioned the word politics, so I'm just interested, judges are humans as well, and they have feelings about politics. So you're not going to be immune to that. So how do you think you would handle or filter that under your obligations?
So I often told the young lawyers that I work with that the intersection of law and politics is a very dangerous place. Many people are run down at that intersection. Politics and politicians are concerned primarily about results. They want to win the election. They want to win the issue. They want to get the bill passed. In my view, judges and the judiciary are primarily interested in not the end result, not who wins the case, but how you get there. What is the reasoning? What is the logic? How should the law be interpreted to reach the right result? Not, I'm going to rule for you because you're of a certain political party, or I'm going to rule for you because you're labor versus management, or I'm going to rule for you because you're the employer versus the employee. It's what is the law, be it statutes, regulations, or the Constitution, and where does that lead when you apply reasoning to that law, and of course, the facts. So I think I view it as a fairly bright line. But I suspect some of my old friends across the street wouldn't like to hear that. But in my view, politics really has no place in the law, in the judicial part of the law. But the role of the judge is to be conscious of perhaps his own proclivities on an issue and set them aside and rule based on what's before him, what's in the record, what are the legal arguments that are made by the parties.
Thank you.
Yes.
What role does technology play in your current practice or going back, in your recent career moves? And then what skill set do you think you would bring to the position in terms of how the court is using technology on a statewide basis?
Great. I kind of hope that would come up. So I've had several experiences with technology in the Kansas courts that are worth mentioning, and I will mention them in the course of the answer. So I am of a vintage, I'll say, where I remember law even before before email. I remember when the computer was put on my desk, and I said, I don't need that. No, you need it for email. I said, no, I don't need email. No, you're going to have it. And that was the beginning of my long relationship with legal technology. I remember when the Westlaw terminal was installed in the Cornell Law Review offices. It would have been 1985 when I was an editor of the Cornell Law Review. And we were all like, what's that? I remember being at the Department of Justice when I was tasked with working on the nomination of Anthony Kennedy to the US Supreme Court. And I was told that, of course, if you remember, that followed the failed nominations of Robert Bork and Douglas Ginsburg. And I was told that, look, we have no room for error. You need to prepare a database of every opinion he has ever written that is data searchable. And of course, today that would be nothing. That would be 2 minutes on Westlaw or Lexis. Then it required me to recruit a team of 10 attorneys within the Justice Department to read every one of his opinions, and there were thousands of them, and write a paragraph summary that was data entered into a computer so that we could search it either at our war room during the hearings on Capitol Hill or at the Justice Department. So that's kind of my history with technology. Of course, now Now we file all of our cases, we file all of our briefs via computer, right? You turn it into a PDF document and you file it. And in the old days, I was a young attorney. We took it to the court and some delightful lady, usually a lady, you'd put a big stamp on it. It was actually kind of exciting to go do it. You got out of the office. Now it's, you hit a button and it's filed. And it's great when it works and it's great when it's not corrupted. So here are my recent experiences. I think the most recent case I listed as one of my most significant was Rivera against Schwab, the challenge to the congressional redistricting map. Shortly after that case was tried, the Wyandotte County computer system was the victim of a malware attack. And of course, that case was on a very short time frame. We lost in the district court. We had to take it up to the Kansas Supreme Court, and it had to be decided because the elections had to go forward. But we couldn't have, we didn't have a record. We couldn't, and normally the records are transmitted to the Kansas Supreme Court in the same manner, the push of a button, and the record is sent to the court. Well, the clerk's office had built this wall and said that, you know, and I see Shima sitting here. Yeah, he's the one who told me. He said, we don't want anything from Wyandotte County because it's corrupted. It's, you know, and that bug will get into our system. So to keep the case going, my team assembled the entire record in paper, just like the old days. And I still have pictures on my iPhone of one of my staffers, you know, the wheelbarrow going from the Attorney General's office over to this building with the record for Rivera against Schwab. You remember it, don't you? And so technology is great when you work. So one of the concerns I would have sort of on a going forward vision basis for the court system is to, I suspect it's already been done, but you can always do more, is to work on the security of the technology. And I know the Supreme Court itself had an incident with malware. So I'm actually very familiar with technology. It's not second nature to me. I have to learn it. And that's one of the benefits of having the young attorneys around. And then they've always helped me with it. The other thing I foresee as a kind of a technology related challenge for the court system, Kansas Supreme Court, and frankly, all courts, you're already seeing it in the news, is the emergence of AI, artificial intelligence. Apparently, lawyers are now using it to write briefs somehow. And AI currently has some flaws, which is that it makes up legal citations that don't really exist. And there are now several instances where lawyers are being sanctioned for having invalid citations in their briefs. And of course, that reveals that they maybe didn't really write the brief, but AI wrote it through a computer. It's a problem. We're probably going to have to deal with that over time in our rules and ethical rules. It came up also the Department of Health and Human Services issued a report federally a week or two ago, what they're calling it, the MAGA Health Report or something. And it was filled with citations that were invalid. They'd used AI to write it, and AI apparently has this bad habit of making up legal citation references, which is not terribly surprising to me as I think about it, because that's a really, what lawyers do in citing cases is actually a pretty unique thing in the culture of literature and writing, right? I mean, you don't hear your congressman or senator citing precedent, but it's second nature for lawyers, right? We're bound by precedent and stare decisis. And I would think that that is an even bigger challenge for those AI folks, whoever they are, to build into their system. So that's those are some of my thoughts on technology.
Thank you.
Mr. Lau, you used the word vision. So I wondered if you could tell us what your vision is for the Kansas judicial branch over the next, say, 5-10 years.
Sure, and it's interesting to hear you use the word judicial branch, because it wasn't always viewed that way in Kansas. There was actually a constitutional amendment, I believe in about 1972, that created the judiciary as we now know it, as kind of an integrated district court, court of appeals, Kansas Supreme Court. By articulating a vision, I wouldn't want to mislead anyone or make you think that a vision is the same as an agenda. Because no one you interview should come to the court with an agenda other than to do the right thing. But I view vision somewhat differently. I mean, vision is, okay, what is the best way to make the court the most efficient, most sort of lawyer and litigant-friendly place to be. And I used up some of my talking points on that, talking about technology. I think that dealing with technology and technology issues as they're integrated into the practice of law, the security issue that I referenced is very important. Thinking forwardly about AI and its influence on the courts and the legal profession. I think those are important vision issues. The other thing that I would like to see worked on is interbranch relations. I mean, having worked in the executive branch, and of course that required me to work a fair amount with the legislature, I saw some of the what I'll call the least fortunate aspects of that. Threats to cut judicial funding because of the outcome in a case, things of that nature. I think there's perhaps more that can be done. People of goodwill and civility should be able to sit down together and talk these things through. I think one of the neat things that occurs that I think is widely known is at least the two governors that I represented got invitations from the Chief Justice to come to lunch. One of them accepted, one of them didn't. And if I had been the chief counsel at the time, I would have told the first one that he should have accepted. But, and so I think maybe more of that. If you know people better, you're less likely to want to characterize them, vilify them. I don't like that word. So I think that part of my vision would be attempting to clear the air for interbranch relations, right? Look, the courts are enforcing the laws that they pass, and they're also, obviously the court's budget, but all, the Chapter 60, right, it governs every case brought in the civil side, and it's passed by the legislature, and it can be amended by the legislature. So there are always going to be ways of doing things or making things be done better that you might think of as a judge or a justice or as a lawyer or a litigant, and they have to go through the system over there. So maybe it's just a familiarity thing, but that's sort of technology and interbranch relations would be my things that I would have a vision for with regard to the court.
Thank you.
Do you have a philosophy with regard to constitutional interpretation?
I have, I would say, something of a philosophy. Judges don't make the law, they interpret it. So it strikes me that it's important to start with the words of the Constitution and then look at how it's been interpreted before. I think it's important, as I referred to earlier, to distill out your own personal substantive feelings about an issue and keep your blinders on the law, the letter of the law and the precedents interpreting the law. I think a good judge would enforce precedents that he or she himself might not agree with, just because part of the engine of our system is stare decisis and precedent. But on sort of open constitutional issues, I wrote a brief that was my runner-up to submit as a writing sample, so you haven't seen it. It was on a death penalty case. It was the Frazier Glenn Cross death penalty case. He was the Jewish Community Center shooter in Kansas City. It killed, I believe, I think it was 5 people because of anti-Semitic bias. And a number of the interest groups had wanted to reconsider the Kansas death penalty, which, the Kansas death penalty is very interesting because it's changed a lot over time. And of course, the Kansas Supreme Court has rejected most of the basic challenges. There are new ones percolating all the time that would be looked at. But one of the things I did there was I said, okay, this is kind of an open question. that hasn't really been dealt with. So I went back and looked at all of the death penalty statutes in that brief, back to the territorial legislature of Kansas. And we were responding to amicus briefs, the most prominent one by a group of law professors, I think mostly from KU. And they had said that it was, Kansas, Kansans loved freedom, and they cited, preambles and so forth, and that the right to life is in Section 1 of the Bill of Rights. So how can you put people to death? And so I said, okay, what's the evidence in the law? And what I found was the same people in the same era who had endorsed and created the Wyandotte Constitution, the first Constitution of Kansas, had also passed many, many statutes enacting the death penalty. And so, and they were very interesting. It was Kansas would have the death penalty for a while, and then it wouldn't, and then it would have it for some things. And it occurred to me, well, doesn't the history show that surely these folks couldn't have meant that there was a right not to be executed in the Kansas Constitution if they were essentially the same set of people at the same time were passing all these statutes authorizing the death penalty. And so that was the argument I made to the court in the Frazier-Glenn Cross case. I briefed it and orally argued it. Mr. Cross actually died, natural causes in prison, before the case was decided. So we made the same arguments in the Carr brothers case, which came up within a few months afterwards. And in that case, the Kansas Supreme Court rejected the argument that Section 1 of the Kansas Bill of Rights included a right not to be put to death when you've been convicted of crimes. Kansas has a very narrow death penalty, as evidenced by the fact that there are very few people on death row, even though Kansas doesn't really have one. Last check, it's 9 or maybe 8. Kansas hasn't put anyone to death since 1960 something. So we have a very narrow death penalty for the most heinous crimes. But I kind of sidetracked there to that's an example of how I would, and it's one I actually got to do in my practice, of how I would look at a constitutional issue and how I argued it there.
Thank you very much.
Thank you. Any other questions?
Do you own any racehorses?
I do breed and own, buy and sell thoroughbred racehorses.
All right. Did you go to the Kentucky Derby this year?
I was not there this year. My last trip to the Derby was 2 years ago. Yeah.
All right.
Won by Mage. It's an amazing event.
That's all I have. I just wanted to ask him a couple questions.
Well, I was going to do that and you took.
Oh, darn it.
All
right. Well, thank you.
Thank you. I appreciate it.
Appreciate it.
Enjoyed visiting with you. Nice to meet you.
Nice.
Good luck with your work.
That's good. Good.
Oh, yeah, it is. Thank you all.
Thank you.
Thank you.
Well, we are scheduled to take a recess. We've used up about 7 minutes of it. Shall we shorten the recess so that we can get back on schedule?
Sure. Sounds good.
Okay, is there a motion to recess until 2:15?
So moved.
Second.
Okay. Any objection? All for it?
Aye.
Okay. We are recessed until 2:15.
Unless it wants to be a full blown hot. Some air moving. It's not pretty.
Stay away. Stay away.
Done with that.
No, I think that way. Yeah, drawing the one after it's like.
Interesting. I couldn't figure out, I talked to him where he was gonna live. Cause he was all over. But he's a bright guy.
They are fun.
I do too.
And we still have like 1 minute.
Did you have,
Yeah, we're live anytime we're gonna go, so. it's up to you.
One of our.
shall we reconvene? We're losing people.
Diane.
No, we lost Ebony too.
She went to get her.
No, I'm supposed to get her.
Oh, who has it?
If she gets her, it'll be fine.
Lori has the next one.
Yes, I do. I was waiting for Ebony to come back. Pardon?
Everybody went to the back.
Yeah, I know. I'm just waiting.
You know, Bob,
Wait.
I haven't had to wait at all for the bathroom today.
Oh, Terry.
Not like, you know, at a rock concert when I was younger and you had to watch out because sometimes the women would be using the men's bathroom because theirs was full. We got it made, the two of us.
Never been such a distinct minority before in my life.
Now I know what my son is a dancer, but he has to deal with. He's the only boy in the whole, usually. Might be one or two others when he goes to a competition, but.
Okay, we're going to reconvene and I will get our next interviewee.
Thank you for your patience. Okay.
Is this the interesting? You'll be interested.
Afternoon.
This is the hot seat, I see.
Yes, it is.
It is.
Well, good, I'm used to those. Isn't that correct, Mary?
So commission members, this is Judge Kathleen Lynch. She's a judge in Wyandotte County and has been for almost 9 years,
19.
19 years, excuse me.
It'll be 19 years in
My
August.
math is bad.
Oh.
I've got it written here. And I have to admit, I was a math major in college and so I have no excuse.
Well, I'm sure it's my younger appearance that probably threw it off.
Judge Lynch, we're glad to have you here today, and I'm going to start out with a question for you. What do you believe you bring to the Supreme Court that is important and is particular to you as opposed to the 14 other candidates?
Well, from start to finish, I was a research assistant for Professor Nancy Maxwell, and she taught criminal law and family law at Washburn. I law clerked at the Kansas Court of Appeals for Judge Patrick Brazel, so upstairs on the second floor. That's where I learned where decisions were made. The carpet was always blue. I have argued before the Kansas Court of Appeals as a private counsel. I served on the Kansas Sentencing Commission with Ms. Marinovich's husband was the chair, Judge Johnson. I was the governor's appointment, and I have presided over sexually violent predator jury trials. I've been a district court judge for 19 years almost. It'll be 19 in August. And I've done extensive work with the intersection of those living with mental illness and the justice system. as well as victims of domestic violence and the intersection with the justice system in custody cases.
And you think that's, you think that?
I think that
is
shows that when I am assigned a docket or assigned a case, that I dig in and I try and learn everything about those topics. And I know there's somewhat of a misconception, I would say, that family law and probate are not complex because they're statutorily driven. But in my opinion, they are very complex in that like in probate, you can have a situation where a person needs a guardian. You've got 5 family members and there's no durable power of attorney. There's no estate planning, and you have to make that decision. And there are situations that arise in family law where a parent has been absent for 7 years in the child's life, and mom has to go on assistance, and then there's a child support order made and paternity established. And then the father wants to be involved in that child's life. So you have to balance his constitutional right to be a part of his child's life with the constitutional right of the child to life, liberty, and the pursuit of happiness in the best interest of that child.
You come from Wyandotte County and
I sure
Sedgwick
do.
County, you elect your judges.
That's correct.
In the Supreme Court, at this point, judges are selected.
As they should be.
And how do you see your role if you were on the Supreme Court, your role towards the public? How would it change between being a district court judge in Wyandotte County and a member of the Kansas Supreme Court?
Well, I used to have this debate with Professor Bill Rich when I was in law school all the time about electing judges versus the merit selection of judges. And I guess where I come down to it from a personal standpoint is, and this is an argument I've even had or a discussion, shall we say, with my colleagues in Johnson County where they are merit selection. At least in Wyandotte County, when you are choosing a district court judge, all of the politics is right out front. You know who gave me money. So if you walk in my courtroom and you are uncomfortable because a counsel gave me $50 or $25, it's all reported on the financial statement. You can tell me that and I can recuse myself from the case. In merit selection of district court judges, you don't have any information about what politicking went on to put that judge on the bench. I think merit selection of the appellate courts is absolutely imperative. And the reason I think that is on the district bench, one decision by a court judge is probably not going to set public policy in the state of Kansas. But if you are an insurance company or a company that's going to have environmental issues or a special interest group, all of that could influence, and they could buy themselves an appellate court judge. The reason I say that is all you have to do is look at the states that do elect appellate court judges and the disaster that they have when it comes to whether or not that decision was fairly made.
I don't think I asked my question well, because what I'm really getting at, how do you face the public? Do you face the public differently if you're a merit selection judge and you're on the Supreme Court versus how do you face the public when you know that you're running for office?
I don't see that I would face them any differently. I see my role as a district court judge in Wyandotte County is, we, as judges, whether we're on the Supreme Court or we're on the district bench, we have to act so that we do not have any appearance of impropriety. And I would still see my role is to educate the attorneys that might need CLE, and I would be happy to present on the topics of which I feel that I'm an expert. I certainly think civic engagement would continue to be very important. I speak wherever I'm asked on probate topics or family law topics at the Kiwanis and that sort of thing. And I think that helps the general public understand the role of a district judge. And I would see myself doing the same thing as a judge of the Supreme Court.
Okay. Anyone else want to ask questions at this point?
How does Wyandotte County divide the cases that come before the district court? Do they have a criminal division and a civil
We have a
division?
criminal division, a civil division,
Probate?
and then they have the juvenile offender court, which is Division 15, child needed care court. I was a child needed care court judge for 2 years, and then probate judge. When I became the probate judge, Judge Seavey, who was our chief judge at that time, felt like our protection from abuse cases and paternity cases were not handled quite appropriately. They had hearing officers handling them. And I used to complain when I was in private practice about that particular issue. So I believe his words were, we're going to let you put your money where your mouth is, kid, and see what you can do with it. And I took on 2 extra dockets. The judge before me only handled probate.
And so right now, what types of cases are involved on your docket on?
You
court?
know, because we have learned that there are a lot of instruments that you can use, so that when you die, your property is not probated through the probate court. That's a very small portion of my docket. Most of my docket is guardianships of those children or adults with an impairment. And I preside over all of the protection from abuse cases that involve custody or involve children. And I have the paternity docket and a large number of cases, adoption cases also.
Now, and you've been on the bench for 19 years. Have you always been with the same type of docket, or has it?
I was moved over to the probate bench on July 17th of 2007. So the last 18 years have been spent in probate and family law, but I did child needed care court before that. And as I said, you know, I signed search warrants every day, signed one on the way up here. Thank God for electronic signatures these days, and do arrest warrants. And I keep abreast of criminal law and civil law because I never know when I might be pressed in to handle a case for one of my colleagues who has a conflict.
So, there's a list of like 7 or 8 characteristics or criteria for us to consider when evaluating all of our candidates. And we've got really great candidates, which is good
It's
for
always
us.
good. It's good.
It makes our decisions harder, but it's good for us. On the context of one of them, which is temperament. What is your temperament, or what does that mean to you, and how?
I have much better judicial temperament than when I first started. I've always said your first day on the bench is not going to be your best day on the bench. Your best day on the bench is going to be your last day on the bench, because you've had all of that experience. I believe that I have an appropriate judicial temperament, and I believe I treat everybody with fairness. I will admit that I'm impatient. I do not like when lawyers are late or unprepared.
I didn't hear your full answer. I do not like
when lawyers are late and do not let me know they're going to be late so I can move my docket around to accommodate that. And I don't like when they're unprepared.
Thank you very much.
Those are probably reasonable expectations.
I would like to think so. If I have a weakness, it is definitely impatience.
And another one of these criteria, these character type criteria that I wanted to ask everybody about is, another one would be impartiality. You know, knowing that you're going to get a fair shake no matter what, whether a Supreme Court justice is your position or whether it's a district court. Is it your belief that when people come to your court, they may not win, but they're not going to be leaving the courtroom thinking that they didn't have a good hearing or that the court didn't listen to them?
When I decide a family law case, for instance, a custody case, it is always, I like to rule from the bench because I don't think that people should wait for a judge to make a decision if they can rule from the bench. Certainly there are some issues that are more complex and you certainly have to take those back to chambers and do a memorandum decision. But if I do that, if I'm ruling from the bench, my position, I usually take 15 or 20 minutes, go back to my chambers or go, now that I'm doing a lot on Zoom, we'll take a recess and I go through the criteria. There are 18 different criteria to decide a family court case on custody. I go through those criteria. I put the evidence that I've heard within those criteria, sort those out with the criteria, and then I rule and I read the criteria and the evidence that tends to go for mom or for dad, or in grandparent visitation cases, grandparents. And I believe because I do that, people understand the way I have ruled and they understand that I have ruled in an impartial way.
So, and the final one of these characteristics that's kind of similar is character and ethics and respect for colleagues.
Mhm.
So tell us a little bit about how you handle your courtroom and how that applies to most of the colleagues are either going to be lawyers or co-judges that you've served with.
Pre-COVID or post-COVID? Pre-COVID, I was usually one of the first ones there in the morning and probably one of the last ones to leave just because of the dockets that I covered. I've always tried to be very supportive of my fellow judges. I'm very proud of the fact that I was only the second female judge elected in Wyandotte County. And there have been, I believe, 5 female judges who have followed me. I have encouraged all of our younger judges or younger lawyers to seek out public service. And I believe that I have always been very supportive of my colleagues. And especially when they are facing health issues and those sorts of things, like Judge Clapper had a very serious illness. And I told him if there was something that needed to be done, that he needed somebody to take care of the case, I would do so.
Okay, thank you very much.
I'm curious. So we live in a dynamic age where the law was written in a different time period than we currently live in, but you still need to apply it to current day. So I'm interested on your thoughts on how do we do right by the law and right by the world at the same time?
Okay. One of my favorite quotes is the law should be stable, but it should not be static. I am one of those people that believes that the Constitution, both the United States Constitution and the Kansas Constitution, is a living, breathing document, and that it should be applied accordingly in the days that we are living in.
Thank you.
If not, then we can go back to muskets and the Second Amendment can apply there too.
Judge, on the district court bench, you have the luxury or maybe the burden of autonomy when it comes to making your own decision. But that changes when you come to the appellate bench, right? Appellate judging requires collaborative decision making.
Absolutely.
So I wondered if you could tell us, or maybe describe a time when you had to reach a difficult decision in a group and had to reach consensus, and perhaps dealing with difficult.
So I think it was in 2017, I'd need to check my notes. I worked with Wyandotte Center, Wyandotte Behavioral Health Network, and the consortium on the Continuum of Care, which was a lot of county mental health agencies group, to pass the Crisis Intervention Act. And that was to establish an involuntary commitment center, brick and mortar, 24 hours, 7 days a week, so that law enforcement or a case manager who encounters someone in crisis can take that person to a involuntary commitment center, meet, and if it's reviewed and they meet criteria, then they stay there. They don't file a care and treatment case unless they've been there for longer than 48 hours. Now, when we were trying to pass that legislation, we got a lot of pushback from people in the disability community because they were afraid that that could be used against someone with disabilities, to family members or that sort of thing, to just sort of get them out of the house and put them somewhere, warehouse them. And so we had a lot of meetings with those individuals, and we explained what we had seen across the country in those communities where they were used. And we explained that we didn't have many times those individuals, I think it was between 67 and 75% of the time, those individuals, their crisis resolved before they were adjudicated as someone living with a mental illness that was a danger to themselves or others. So in fact, it did not stigmatize an individual who was living with mental illness. But those conversations were really difficult. They were very passionate. I was very passionate about the legislation because I absolutely believe that if we can do that, it's going to reduce the care and treatment docket, and it's going to de-escalate a lot of what the folks living with mental illness suffer on a daily basis. But those were difficult conversations, and some of them were held in meeting rooms like this, and some of them were held right outside the meeting rooms when we were trying to get the legislation passed at the State House.
I have a question. You know, we live in a pretty politically divisive time. Do you think the Supreme Court should play a role in addressing public perception of issues or the public image of the courts and judges? And if so, what would that role be, and what would you do?
Well, certainly, we cannot comment on a case that could come before us, obviously, an issue that could come before us. I will say this, I am somewhat depressed by the number of people who don't understand that we have 3 branches of government. And I'm kind of a history nerd and a government nerd. So it's depressing to me that some people don't know that we have 3 branches of government, that we have a municipal system and a state system and a federal system, that there is a system of checks and balances, and that when judges rule and say that something is unconstitutional, we're not bad, we're actually doing our job. And so I think that there needs to be more civic engagement on the education of the role of the courts, not necessarily decision-making with an issue before us, but certainly the role of the court. I've tried to do that as much as I can in Wyandotte County by going to high schools and grade schools and those sorts of things. I was at the State House not too long ago, and there were people who asked to take a picture with me from high schools in Wichita because they'd never met a judge before. So I was more than happy to pose for that photo with them. So
Great. Thank you.
Your Honor, do you view your, I'm going to use the word limited exposure to the criminal arena as a weakness for you at all?
I wouldn't say it's limited at all. I was a prosecutor for 2 years in the municipal court system. Many times we were trying felonies, the DA just had not filed them. I have tried the sexually violent predator trials. The state is still on the burden of proof as of beyond a reasonable doubt to prove that they are a sexually violent predator. They are in jury trials. My domestic violence cases many, many times dovetail with felony cases. And I sign arrest warrants and search warrants every day. So I don't believe I have a limited experience. Do I have a limited experience in presiding over criminal trials? That's correct. I've tried 3 in my presided over 3 in my career.
What is it about you that you believe separates you from the other 14 candidates?
I believe my experience from law school as a research assistant, a research attorney for Judge Brazel, arguing before the Court of Appeals, understanding, having the exposure of the Kansas Sentencing Commission. I understand their role better. I also think that this is kind of a joke that I tell everybody. I'm a workhorse, not a show horse. I'm a community college kid. I'm not a country club kid. And I went to a small high school. I think my graduating class was 162 kids. I worked my way through college. I worked my way through college at the Wyandotte County Courthouse. So on my breaks, I would sneak up and watch jury trials. And that's what the exposure was. I spoke to attorneys. That's how I decided to go to law school. This may be insulting to some people, but I found the attorneys that I seemed to like better went to Washburn, and that was a big decision. Certainly the scholarship they offered me, I was a scholarship kid. So my dad was a telephone man and my mom was accounts receivable clerk at the housing authority. So I came to the law, it sort of drew me in. So I think that's what makes me unique.
Thank you.
That and my choice of shoes.
You talked about working this legislation
Mm-hmm,
and introducing or talking to people who didn't quite agree with you
mm-hmm.
and working with them. I think it's a little different on the Supreme Court because there's 7 justices and they're working collaboratively and they are working for the same goal, coming up with the right decision in a case.
Mm-hmm.
And do you think you could, what do you bring to that kind of relationship?
Well, I think that I have shown throughout my career that I have collaborated with a lot of different groups. And I don't really see it any differently because once you have a goal as a group, then you certainly need to sit down and discuss why you believe your position is correct if you are deciding a case. And certainly you have to listen to your colleagues and their positions also. And I believe that absolutely that based on my experiences, what I observed as a research attorney for Judge Brazel and the decision-making process that went on with those cases, I think I could absolutely collaborate with anybody and on the Kansas Supreme Court.
And be able to have coffee with them the next day?
Oh, sure. You know, my favorite part of practicing law in Wyandotte County was you could go into the courtroom and, you know, you've had to knock each other around sometimes in cases. But we all ended up going to the same place that afternoon wasn't necessarily, I'll be honest, Chairperson, it was not always coffee that we were drinking, but we all went to the same place the next day and you know, that afternoon or the next day, and you got through that. I mean, that's just part of being an adult. I know that society is very, very divisive today. I know that I have brothers that are politically different than I am, but brothers and sisters in the community especially, but we are able to find consensus. And I'm one of those people that absolutely believes that if I can talk to you for 15 minutes, there is a common thread that we can find that connects us.
Okay. Other questions? No. Do you have anything else you want to say to us?
Well, one of the things I would like to say is that I have deep regret that there is an opening on the court due to Justice Wilson's illness. She came down to my courtroom to observe our care and treatment docket process before she became a justice, and I appreciated her willingness to learn from the process that we had developed and take what would work back to Shawnee County. You know, I'll be starting my 19th year on the bench, and if the worst thing that happens after today is I go back to doing my job as a district court judge, then I'll be fine. The universe will provide another challenge for me to overcome in the court system, and we'll work it out. But I absolutely believe that I have done my best by those in the marginalized communities, those folks living with mental illness, people that have suffered domestic violence. I have worked within my community to come up with solutions to those problems that maybe nobody really wanted to tackle because they were considered the redheaded stepchild of the court system. And I will say this, the work that we did in Wyandotte County is the exact reason that we had a symposium on mental health in 2022 in Topeka and people from across the state came. And in fact, I know that Chief Justice Lukert said, don't tell me you can't do it without any money, because I'll point to Wyandotte County. We were the catalyst that brought on that sea change, and I am extremely proud of that. And I believe that by providing the court clerks, the entire court clerks system information on domestic violence, and sometimes explaining to them the reason that the case has been dismissed 6 times is because the average is 7 times before a woman leaves the situation where she's been abused. And I say woman because about 87% of the time that is the case. I believe that in educating those folks, I've had a large impact on the system in the state of Kansas, and I would like the opportunity to continue to do that, but to do it from upstairs on the 3rd floor.
Okay.
All right.
Okay.
Well, thank you very much.
Thank you.
Thank you.
I appreciate your
Thank you.
time and I appreciate your service to the state in this process. Thank you.
Thank you.
Okay, fellow commission members, I'd like to introduce Kristen Diehl. Kristen resides in Wichita, but she offices in Topeka as the chair of the Kansas Board of Tax Appeals, a position she has recently been unanimously approved for a 2nd term. Kristen graduated at the top of her class from Washburn School of Law, worked in both private practice and as a law clerk for the Federal District Court. Thank you for coming.
Thank you for having me. It's a pleasure to be with you all today and a real honor to be able to interview for Justice Wilson's position, although I wish it was in happier circumstances.
Well, I'll ask the first few questions, Kristen, and then we'll open it up to the colleagues. What has motivated you to pursue a judicial career, and what does public service mean to you personally?
Something that has motivated me to pursue a judicial career, well, really my background is I grew up with a judge for a dad, as many of you probably know. That was something that I had thought about doing from a very young age, but I sort of took a meandering path to get to where I am today. I didn't necessarily think when I went to undergrad that I was going to go to law school, so I studied biology. And about my 3.5 years through, I took some environmental law classes, and it was like a little light bulb went off that maybe I could combine a couple of things that I love, science and law. And that motivated me to go to law school. Then I went into private practice, and being a private practice lawyer, I enjoyed it, but judicial aspirations seemed like something that was for somebody else who had more experience, more years in service than I did. I didn't necessarily know that I would ever make it there in my career. But at some point I had an opportunity to go work for Judge Martin at the federal court, and that changed the trajectory of my entire career. I loved working for him. I loved being on that side of the bench. I'd always, appreciated a lot of what judges do and been exposed to that, but working for him, I had a real opportunity to observe that I enjoyed being in that position, not having to be an advocate for one side or the other, but being able to look at both sides of an argument, really dig into all of the issues and the law and the research and make what was the right decision under the circumstances. And at that point, I decided that was what I wanted to pursue. And was fortunate then to end up in the position I am now, where I have a quasi judicial role, and I am able to serve in that function. And that has really solidified that this is what I want to do. It's where I want to be. And I can't think of anything that is a more of an ultimate service to the bar and to the rule of law than to be a judge, but in particular to be a justice of the Supreme Court.
In my conversation with Judge Martin, who spoke very highly of you, he described you as the epitome of a public servant. What do you think he meant by that? And what does that field of work or that passion mean to you personally?
Well, that's very flattering that he would speak highly of me and that he would say that. I think what he would mean by the epitome of a public servant is someone who's willing to put the betterment of the community above my own personal interests and gain. And that, someone who just has a real deep personal commitment to promoting the profession and advancing the rule of law. And someone who in sort of all facets of life looks at how I can better serve the interests of my community and the interests of my profession.
Hey, Kristen, we learned today from the Chief Justice that administrative responsibilities account for about 60% of the work of the Supreme Court. Can you speak to your unique skill set and understanding of this administrative area?
Yes, I think I got a little bit of a flavor of that in working for a Judge Martin. I had a unique role for him because he was the senior status judge. He had fewer clerks than normal. We had 2 in chambers and we were the only staff. And so in addition to doing traditional clerk roles, I was also his chief administrator. And I had a little bit of a background in just understanding how a court system ran, how to move dockets, how to communicate with parties, how to schedule cases, that kind of thing, working for him. When I got to the Board of Tax Appeals, I didn't know how invaluable that experience was going to be to me, because I think that there are times where in my current position, it has felt like 90 to 95% of the work I have done has been administration. And, that may be an exaggeration or just the way it felt at the time, but we have really gone through some tough periods at the Board of Tax Appeals in the last year or two with staff shortages. We have the same budgeting concerns that the judiciary has, continually being asked to do more with less resources. I have stepped, I think, into the role of administration more so than any of my other predecessors in the chair position. For a long time, we were short an executive director. That individual retired last fall, but before she retired, she was medically absent for quite a long period of time. We've also been absent our chief finance officer. We've been short a staff attorney for nearly a year. We finally got someone hired for that position who started yesterday. So in these sort of staffing shortages, I have stepped in. I feel like I've been the board lobbyist. I've been intimately involved in preparing the budget every year. I've dealt with HR issues from hiring to other issues. I'm dealing with our back end docketing processes, continually trying to improve those. The IT, I have been incredibly involved in IT from day one. When I started, we were in the middle of COVID and the board had taken no steps to move to Zoom. I think effectively the board had basically shut down and not done hearings for approximately a year because there was no infrastructure to do it. And I think frankly, because nobody on the board at the time had come from the court system like I did, nobody had seen a Zoom hearing happen. They had not had that experience. They didn't know it would work. I mean, working for Judge Martin, I had held those Zoom hearings. I had scheduled them. I understood that we could make that work for us. And so I was able to get a Zoom room installed, start scheduling those Zoom hearings, establish the processes for the parties to request those, figure out how we were going to deal with submission of evidence. We've since expanded the use of Zoom to our small claims court. We have parties extensively using that now who are from Western Kansas or more rural areas who don't want to drive 4 hours for what may be a 30-minute hearing. At the same time, we had technology infrastructure that had not been updated since 2008 that I inherited. So I immediately began trying to work on improving that. I was able to obtain about slightly under $500,000 worth of grant funds to work on that. That has been a continual project the entire time I've been there. The website hadn't been updated since 2008. We're working on a contract right now with a company to rehaul that entire website infrastructure for us. So when I think about all the levels of administration at the board, I could think of very few things that I have not touched in at least some capacity. And I understand how critical that work is to just the ability of the board members to do what we are supposed to do, which is just sit and hear and decide the cases. None of that happens without all of that extensive staff support and that back end structure.
Thank you. One more question. Kristen, what do you see as some of the most pressing issues facing the court in the next 5 to 10 years?
Yeah, so I've thought about this, and one issue that I keep thinking about is AI. And I know that the court has been, working on that in some capacity. Judge Hill has talked about it pretty frequently in different meetings that I've been in with him. I think we've got the issue with AI as lawyers of the issue we've all heard. People using it to write briefs, it hallucinates cases. You can't really tell when somebody's used it and when they haven't. We're aware of the potential downsides of AI. I think the courts need to be proactive on how we're going to address that, both in the state of Kansas and frankly nationally. But we also have to look at what are the potential good sides of AI. And is there a way that we can use that to our advantage? I mean, we know we have an attorney shortage. Obviously, the Rural Justice Initiative has identified a lot of gaps in the rural parts of our states, but generally we have an attorney shortage. Are there ways that we could be using some kind of AI model to help people who don't have access to an attorney? Are there programs that we could use to help draft something for someone that would then be maybe reviewed by an attorney who's in another location? Can we use AI programs to help pro se litigants? Because my understanding is that even at the appellate court level, more and more cases are being brought and handled by pro se individuals. And that's something that I see a lot in my position, where we have really no meaningful resource to help pro se parties. They need assistance. They need access to those resources. So are there AI resources that we could be using for that? And I also think, we need to look at standardization. And I know there are a lot of district court judges who probably would give me the side eye on that. But I talked to Justice Lukert fairly recently about this. And I said, we have used Zoom court to pretty great commentary from a lot of people who don't have to come to hearings now. But I understand among my practicing friends that are still traveling a long way to represent individuals that not all judges have really embraced Zoom. Is that something, do we need to provide more resources for judges to feel comfortable with that? Do we need to make, standard rules for how and when Zoom appearances should be allowed? Would that help with the attorney shortage in some of these areas? If the barrier to someone being able to hire an attorney from Wichita is that every time that person has to appear for a preliminary hearing or a plea deal or something, that client is being charged 3, 5, 8 hours worth of travel time in addition to the appearance fees, that's a barrier to justice issue. So I think that we need to be, looking at innovative ways to use technology and seeing if we can get all of our court systems in the state kind of on the same page in that regard.
Kristen, thanks for being here. I heard many great things about you in relation to your education, educating people in the professional association with British Lauer Association. I guess my question is we know that when the court engages with attorneys, public and government, better services provided. So how do you view the relationship between those entities, and where do you see rooms in?
The relationship between the court and the public and other entities. Yeah, I think that's particularly critical now when we are seeing a lot of attacks on the judiciary, that members of the court still be involved in community organizations and bar associations, because now I'm going to use a zoo analogy here. So forgive me, and I'll explain to you why I'm using this analogy. But my husband was a zookeeper for 20 something years. And I'm also, being a biology major, a bit of an animal person myself. And, zoos often come under criticism for keeping animals in captivity, but there's also this side of conservation that says people are not interested in conserving what they don't know and love, right? And the way to get people to know and love animals that they wouldn't otherwise come in contact with is to have them available in zoos. Well, I think the same could be said to be true for our judicial system. People can't know and understand and appreciate the work that judges and lawyers do if they don't know judges and lawyers. It's very easy to sit and criticize and attack and belittle and demean someone for doing their job when that someone is an amorphous figure to you who's sitting in an office in Topeka or Washington, DC, or wherever you envision this person to be, and they're not a human being to you. They're not someone who you've talked to in a council meeting or sat across with, and, you know, had a drink at a bar. Very easy to not understand that person's commitment to their role. But when we have these personal relationships, I think people start to see these are human beings. They're doing what they think is best. They're dedicated to their profession. They're someone who's doing the best they can every day, just like I'm doing the best that I can every day. So to that extent, to build those relationships, I think it's very important for judges to stay active. And I also think it's very important for judges and justices to build relationships among different entities of government. So that's, you know, one thing in my position. I'm an executive branch employee, but I have tried very hard to maintain a good and, well, in fact, build a better working relationship with the Senate committee that we deal with most of the time, because I think it's important that we have that good relationship. And we don't always agree. And there have been times where I have said as much to them in budget hearings or in informal discussions. But that was one comment that I got during my last confirmation hearing, was that those, particularly the chair of that committee, appreciated my professionalism and the way that I had always related to them. But I think that there could be more of that in government. And what I said in that hearing was, I do appreciate the back and forth between us, because I don't think that that is always the case between agencies and between the legislature. And I don't think it's always the case between the court and the other branches of government.
So what's your favorite library like dinosaurs?
Oh, I don't know. Oh man, it would probably, you know, well, we'll say, because I have a 4-year-old at home, Bluey the cartoon dog. Yeah.
Your Honor, what is it that you believe? We've got 15 candidates. They're all qualified, clearly qualified.
Yeah.
What do you believe separates you from the others?
Yeah, I do not envy your task, because I know that everyone is eminently qualified. Like I said earlier, I think over the course of my career, I've always done things a little bit differently. You know, from the time I went to undergrad, I didn't have a poli-sci major, a psychology major, an English degree, a journalism degree. I studied evolutionary biology. So I think, you know, at the outset, that science background really started me off with an analytical perspective on everything. And it worked really well then when I got into legal work, to have already my brain kind of tuned that way to be analytical. But in private practice, I didn't do a lot of necessarily what I thought I was going to be doing when I came out of undergrad. And that was fine. I enjoyed my time there. But just about the time, you know, 12 years into private practice, when most lawyers would have been hitting the upswing and really been getting into the stride of potentially partnership, or, you know, just feeling very comfortable with their practice, I hard pivoted and went and took a term limited judicial clerkship. Not only limited in terms of being a clerk, but limited in that I knew the judge I was going to work for was about to retire in 2.5 years. That decision, I think, to a lot of people probably made absolutely no sense whatsoever. But like I said, had I not done that, had I not taken that chance and done something a little risky and unusual, I don't think I'd be sitting here today. I wouldn't have realized that this was what I wanted to do, and I wouldn't have gained the confidence to do it. You know, and I did stay there for 2.5 years. And at the end of that, rather than maybe trying to stay at the court and find a full-time position or go back into private practice, I did something else that was a little bit risky, and I took a term limited position with a state agency. So I went from federal government to state agency. And not only did I go to the state agency, but I went ahead and jumped on as the chair of that agency, even though I'd never practiced in front of the Board of Tax Appeals. You know, I don't know that people really understood that decision at all, but that again made a world of difference to me in cementing that this is what I want to do. So I think the fact that I go at problems maybe a little unusually, I'm not unwilling to take risks, and I can think outside of the box. I think that's what sets me apart from your other candidates, because I have shown, I think if you look at my background, that I have the academic capabilities to do this job, that I'm an excellent writer, that I have a reputation for having an even keel when I'm on the bench. And that's probably not unlike a lot of your other candidates, but I do look at things a little bit differently. I'm not afraid to push for change if I think it's appropriate, but I don't change just for the sake of it. You know, there's always a basis for it. And I think that that's what the court needs, is someone who's not afraid to take a little bit of a risk every now and then.
Do you have a philosophy with regard to constitutional interpretation?
You know, I don't think I have a set philosophy at this point in my career. I have thought about that question in depth, and my fear of calling myself out as one thing versus another is that I unwittingly pigeonhole myself into a situation where I may say that I am, you know, perhaps a strict originalist, and then I am presented with a set of facts where that interpretation just doesn't make sense. But I've held myself out as being someone who fits into this box. And then what do I do? Does that make me seem dishonest if I've claimed to have a particular philosophy? You know, I think that I'm someone who just looks at the facts and the law of each case and tries to make the best decision that I can, and is not pre-constrained by any particular rubric in that regard.
That'd be equally true for both the United States Kansas Constitution and the Kansas
Yeah.
Constitution.
Yeah, I think I would have the same philosophy both ways, that I'm just going to look at the case and I want to be able to do it with an open mind and not go into it with any sort of preconceived notions or leanings as far as how I have to make that decision in that case.
Thank you.
Questions? All right, Mr. Lassiter.
Last, maybe not least, so Kristen, tell me about which part of your broad experience you think would be the most helpful to you on this job of being a Kansas Supreme Court justice.
I think that definitely what I've done with BOTA is the most helpful to me. And I've already talked to you all about the administrative aspect. So let me talk to you a little bit about the case handling aspect. I think what a lot of people don't realize about BOTA is that we're handling an average of 7,500 tax appeals a year. You know, I can say that number and immediately get some eyebrows raised. About, I would say 5,000 to 5,500 of those come through our regular division, which is primarily where my responsibilities are. I preside over every matter that goes to hearing in our regular division, with the exception of maybe something that happens while I'm on vacation or sick. But for the most part, I preside over everything. And I estimate that I've presided over more than 1,300 hearings in the last 4 years, where I've been with BOTA, and that has resulted in over 1,000 written summary decisions and more than 200 full and complete opinions. I estimate that I've signed over 6,000 exemption orders as of today. And I think that people don't realize that BOTA is that busy. But I have, like I've said, an intimate knowledge of the pressures of handling a very busy docket and the importance of moving cases along. And I understand completely where parties get frustrated that decisions take too long from us. But I also understand all of the reasons why sometimes we can't get decisions out as quickly as people want us to. And frankly, I have not been unafraid to go advocate for the resources that we need to be able to do what I think is a better job processing those cases. Now, my advocacy has not always been fruitful in that regard, but I have not been afraid to go out and say, you know, we need more individuals or more technology resources to be able to do this in a better fashion. But I think the fact that I have directly worked with so many cases, presided over them, worked on the panel to get the decision, worked with our staff attorneys to draft and craft that decision. If I didn't outright write it myself, which I do still sometimes because I enjoy that. That all to me directly translates to what I would be doing as a justice. And I think to that extent, I would feel very comfortable moving over into that position.
And how many people are on the Board of Tax Appeal that would hear an appeal
Mhm.
that you, I think, preside over as almost like the judge?
Yes.
Preside over a trial? How
Mhm.
many total people are there that are there from the Board of Tax Appeals that help make the decision?
Mhm. So there are three of us. All three of us sit in each case together. It's the same three of us. We do have a fourth, we have a chief hearing officer who can sit in as a board member pro tem in the event that one of us is unavailable for some reason. And so he does occasionally sit in, but for the most part, it's the same three board member panel of us. I'm the only attorney on that panel. By statute, we're made up of an attorney, an appraiser, and an accountant. So that is another unusual circumstance where I'm often the only kind of legal voice in the room. And there are times where that's challenging, but there are also times where that's been incredibly helpful or refreshing to have different perspectives on something in a room, particularly with the type of work that we do. So, you know, we work very well as a panel together, which is a good thing because we work together a lot.
And then there's a written decision that
Mhm.
says, yes, it's exempt or no, it's not exempt. Isn't exemptions the typical or the most likely issue that comes before that?
I would say exemptions are the most voluminous issue that comes before us, but most exemptions don't go to a hearing. So the majority of cases that go to a hearing are equalization appeals where a party's contesting the value of a particular property, whether it's a residential property or commercial property. And I would throw tax protests in that category as well. The real difference between those is just the timing of when the appeal is filed and whether taxes are paid before or after the fact. But they're all questions of valuation and sometimes classification of a different type of property. Those are the vast majority, but within that, we see all kinds of issues. We see jurisdictional issues. We see heavily fact-dependent questions. We see sometimes conflicts between different statutes. We've had more than one issue of first impression in the time that I've been there. I had a case that turned on our interpretation of Robert's Rules of Order. So, I mean, I'm not sure how many judges get to deal with that kind of question.
So then you issue the decision. Is that the end of it, or is there an appeal process that somebody who's not happy with that decision can proceed to the Court of Appeals or the Supreme Court, or is it automatically the Supreme Court?
It's not automatically the Supreme Court. So it's actually interesting with us, the legislature introduced a statute that allows someone to decide when they want to appeal. They can either go to the Court of Appeals and the standard of judicial review applies, which is typically abuse of discretion for us, or they can choose to appeal in a district court where the property is located, in which case it's a de novo proceeding. If we do have procedures, of course, for reconsideration, if where a party can ask for reconsideration first before they go on and pursue other remedies.
And do you handle those cases too when they either go up to the Court of Appeals or to the district court?
No, once they go on for appeal, we're done with those, just like a district court would be basically done with it, other than participating in the record, unless there have been some instances where we've been involved at the district court level because the litigant either tries to bring us in as a party. That's happened either the board as a collective, or in one case, I had an individual who tried to bring the individual board members in as parties. Then we had to be involved in order to ultimately be dismissed. We sometimes get involved if there are questions of a party wanting a record and, you know, the circumstances of getting a record or a transcript. We've had some involvement, but typically we don't represent the board in those proceedings. We don't guide the courts in that way.
Very good. Thank you. That's more experiences, almost like a judge than I thought.
That's why I refer to her as Your Honor.
You know, people often sometimes don't know what to call me. So I've been called all kinds of things at hearings.
Anything else? Well, thank you, Kristen.
Thank you all very much for your time this afternoon. I appreciate it.
Thank you. Thank you so much.
You're on downhill run. That's.
Be okay.
So.
My kids say, Dad, don't yell. I'm not yelling.
Right there, here's.
Good afternoon.
Good afternoon.
Hey, colleagues, I'd like to introduce you to Anthony Rupp, Tony. I believe
Tony.
is what you go by. Mr. Rupp is a 1983 graduate of Creighton University School of Law. He began his career as a law clerk in district court. You correct me if I have any of my facts wrong. And then moved on to private practice, specializing in civil law. For the past 12 years, he's been with Fulston Seifkin, where he has litigated high-profile cases and class action suits. He has recently been named one of Kansas' top commercial litigators by Chambers USA. Welcome.
Thank you very much.
So
Pleased to be here.
I'm going to start off. So I've got a question for you. When you think of the requirements of your current practice as what I would describe as predominantly a civil litigator, compare it to what your understanding of what the position would require as a Supreme Court justice, what do you see as the biggest adjustment you'll have to make? And what do you think you might struggle with?
Well, I hope I don't struggle with any part of it. I think I've got experience over 42 years that covers the wide range of litigation, including a certain amount of appellate work. Obviously, I have not done a criminal law practice. There's a fair amount of criminal law work that goes on in the Supreme Court. That having been said, I think the Supreme Court is regularly dealing with facts and the law and the legal standards that are applied. And I believe that over the course of my experience, I am always having to deal with novel issues that I have not dealt with before. My practice is not a repetitive practice where I'm constantly dealing with the same sort of case. Rather, frequently I'm dealing with an entirely new area of law for me when I'm handling cases. So at least I'm hopeful that the issues associated with being a Supreme Court justice, whether they would be trial related, management related, working with colleagues, I feel like those are all things that I've done before, and hopefully I've got the requisite experience to be helpful in that regard.
You just mentioned several skill sets that are required to serve as an effective justice. You have a lot of litigation experience. How valuable do you think your litigation experience is to becoming a justice?
Well, I think I understand the issues that come before the justices. Everything I've done is in a litigated, has been litigated in some fashion. And so I believe because the appellate courts are dealing with matters that are coming out of the district courts, they're dealing with administration associated with the district courts. They're dealing with ethical issues and dealing with lawyer discipline. I've dealt with those things on the other side. So I believe that that kind of litigation experience is important and valuable. And I think the opportunity to have been in front of district court judges and to understand what they do is something that I think I'd bring to the table.
You mentioned briefly the administrative and managerial role of the Supreme Court. Can you talk a little bit about your background and what would, how that would benefit you, what skills you would bring to
Sure.
that component? Justice Luca was in here earlier today and she said, what did you say, 60% of the work of the court is more managing than adjudicating?
Sure. And here's where I think that that my background is particularly helpful in that regard. And I think you're all familiar with Folston and that it's the largest firm in the state. I have served in 2 management roles with that firm. First, for 7 years, I was the partner in charge of the Kansas City office, which is based in Overland Park. We're about 25 lawyers. So all aspects from budget to, hiring and firing and all of those types of things, certainly was in charge of all of that. In addition, I served for 6 years on the firm's executive committee, which is the 5-member managing committee that deals with everything from the budget to the overall strategic plan of the firm and how to deal with COVID and, all of those types of things. I was the first person outside of the Wichita office to serve on the firm's executive committee. I think that you should have in your packet, I believe, a number of letters from various of my colleagues at Folston talking about management skills. I agree, as I understand the role of Supreme Court Justice, and I think at the highest, it's get the law right and equal justice to all. But I certainly think the management and dealing collaboratively with the district courts and the Court of Appeals and the other administrative aspects of committees, I think that my administrative and background or management experience also have served in various other roles, including as chair of the Overland Park Chamber of Commerce, that I think also deal with management and decision-making, budgeting, that I think are valuable to what the justices do.
Thank you. I have one last question. And you mentioned something about references, and yes, you have a very impressive supply of references. Some of people
Thank you.
Submitting written.
I've been around a long time.
But I guess my final question is, there are 15 applicants and they all have diverse backgrounds and strengths. So what's your value added? What makes you stand out from the rest?
Sure. And let me start. I'm not running against anybody.
No.
I think what I bring to the table is experience, both from the litigation perspective, including appellate, management perspective. I think by reputation, and in fact, I am well known for preparation. And I think that being prepared is critical to the role of a Supreme Court justice. And I'm also, I think, well known for collaboration, and everything I do is in collaboration with others. I'm usually the lead attorney on a matter, and we'll have several attorneys and paralegals working with me on those cases, frequently co-counsel in those cases. I think typically I try to work well in those cases with my opposing counsel. Sometimes that's impossible, but almost all the time I work well with opposing counsel. You know, I believe that, you know, certainly with regard to decisions that the Supreme Court will make, there are going to be differences of opinion, I think, but as I think you can disagree without being disagreeable, and I would hope to collaborate with the other justices and their offices on trying to find the right result.
Well, thank you.
This point.
Oh, my.
It's usually me who has something like that happen to me.
By phone. You mentioned having attorneys and paralegals working on cases. In your current practice, what percentage of your research are you doing? And then I'm going to ask you the same question with respect to writing, whether it's briefs or memorandums in support.
Sure. And I've been doing this for 42 years, so I've certainly got tons of experience where I was the primary drafter of briefs. Most of the time today, and there are some briefs that I take the first draft of and finish them up. More often in my role today, I have one of the younger lawyers draft the first draft, and I edit it, sometimes completely, sometimes not so much. But yes, I mean, it is a collaborative practice, and I do have people working for me, and I'm usually the one directing the work and saying, here's where it ought to go, and looking at it and saying, no, I don't like this, or hey, this is perfect. You know, and so, yeah, I mean, the advantage of a firm like Fulston is the ability to have bright young lawyers working with me, and I clearly do that.
Okay, so then I guess my next question has to do with your comfort with technology. What's your understanding of how the Supreme Court utilizes technology statewide, and what skill set would you bring to that?
Sure. I am a person, I mean, I use all of the tools available. I liked GEMS better than I like the current system that's available statewide. I'm certainly on Pacer all the time. Westlaw and Lexis, we have both in our firm, and I use both regularly. I double check the cases and will you know, if the other side writes a brief, I check their sites. So I don't rely entirely on the associates or younger partners to do that. I'm very comfortable in Lexis and Westlaw. I will tell you that on citation form and getting the blue book right, I rely on others. But in terms of I'm very comfortable with technology. Certainly was involved with, I mean, had cases before the Kansas courts when technology failed, just 2022, I believe it was. And I'm not claiming to be the IT specialist. I rely on others. We have IT specialists in our firm, you know, but I'm very comfortable with everything that I believe a lawyer or a justice would need to do in terms of the research that's available online and the site checking that's available online. And I do that. Mm-hmm.
Oh, sorry, go ahead.
Is there anything that is not on your application about yourself or your experience that you would like us to know?
I think probably the one thing that probably the elephant in the room with me is my age. I'm 67 years old. I do, as part of that, it's kind of the question, you know, how long does this guy want to do this? Is this something that he really wants to do? And the answer is yes. I believe that the opportunity to provide public service for the last whatever number of years it might be, and the constitutional amendment has something to do with that, I suppose. But, you know, if over the next 9 or 10 years until I'm ineligible to run for the retention, I were in this opportunity to serve as a justice on the Kansas Supreme Court, I would take it seriously. I would be well prepared, and I would work well with the district courts and the Court of Appeals. And I think that's part of the collaborative nature that I would hope to bring to the court. I'm not sure that, you know, I grew up in Hayes, spent a lot of time in Western Kansas. I'm not sure that anybody would claim me there now because I haven't really lived there since 1976. But I do have a great fondness for the western part of the state, and then I've been in a firm that has offices, of course, in Wichita and Topeka, and I've spent a lot of time tried a case it was Wichita trial, but based out of Dodge City, representing the city last year. I really love the entire state of Kansas, and other than college and law school in Omaha, I have spent my life in Kansas.
Thank you.
Mr. Rupp, do you view your absence of experience in the criminal arena to be a weakness for you?
I don't. So going back as far as law school, I won the Amdur Award, I think, in either Crim Pro or Crim Law. I can't remember which one, which was the highest grade. Clerked for Judge Saffels, and we tried criminal cases there. I've dealt with criminal cases on the periphery by handling Section 1983 cases representing law enforcement a number of times over the years. I'm familiar with the process, but it is true, I have not tried a criminal case. I do think that I understand the concepts, the facts, and the law, the statutes that are involved in criminal practice, have the advantage in a Supreme Court situation of frequently it being a legal issue by the time it gets to the Supreme Court. And I think I am, as I indicated earlier, quite capable of and experienced in taking on things, new issues. Certainly when we did the congressional redistricting case under the Kansas Constitution, that's not something that I or anybody else had ever dealt with in the state of Kansas before. The procurement case that we did last year is completely new issues to me. I think we handled it pretty well. The Voting Rights Act case that we tried before Judge Melgren last year, largely new issues, some relationship to the congressional redistricting case, but largely new issues. And I feel like I take the time to become familiar with the law and we'll dig into it and dig into the facts. I recognize the importance in every case, be it civil, criminal, administrative, whatever the facts and circumstances may be, of getting into the transcripts and understanding the case, understanding what happened at the district court, what happened at the Court of Appeals, and understand the legal standards that are applicable at the Supreme Court. So I'm very comfortable with that, acknowledging up front that I've never tried a criminal case.
Do you have a philosophy with regard to constitutional interpretation?
I believe that there are recognized standards for constitutional interpretation that have been used by the appellate courts for years and years. I am not an originalist who puts the original interpretation above everything else. I am a person who believes that the whole gamut of recognized standards for construction of constitutional issues have been established over many years and take into account precedent, take into account the words of the statute, obviously Kansas and US Constitution and interpretation of those, but certainly the importance of precedent, the importance of the standard of review that might be applicable, whether it be strict scrutiny or otherwise on constitutional issues. I've dealt with constitutional issues and I've dealt with a number of statutory issues that represented the state on a number of statutory interpretation cases, including constitutional cases.
Would your approach be the same with regard to both the Kansas Constitution and the United States Constitution?
Well, I don't believe on the US Constitution, a member of the Kansas Supreme Court can overrule the precedents of the United States Supreme Court. I think that's, got to stay in your lane. But certainly I think to the extent that it hasn't been decided by the US Supreme Court, or to the extent that it is a Kansas constitutional issue, which is its own animal, I would say that the standards that I've talked about would be the standards that I would apply.
Thank you very much.
Mr. Rep, do you believe that the courts have an obligation to improve public understanding of the courts? And if so, how would you carry out that obligation?
I believe that the courts do have that understanding. I do think that the steps that the Kansas Supreme Court case or the Kansas Supreme Court does, including going out to places like Logan. And by the way, I'm somebody who'd been to Logan a long time ago. I know where it is. I think that's really important to the extent that the ethical rules and judicial conduct permit certainly education and kind of the whys and wherefores of what the Supreme Court does. I have not studied how much a Supreme Court justice is allowed to get involved in the upcoming campaign, and I suspect that they're not. But to the extent that it's possible, certainly providing education, not advocacy, I think is something that when I was in the chair of the Kansas or the Overland Park Chamber, for example, we had Justices Stiegel and Wall come and speak to the chamber to kind of address what the Supreme Court does, how it's selected. And we're dealing with really bright people in the state of Kansas, most of whom don't understand any of what this commission is doing and how judicial selection works, what the Supreme Court does. And I think to the extent that, I'm invited to speak to a bar association, a chamber of commerce, a PTA, a Kiwanis club, I'd be, more than happy to do so. And, in those districts that would be assigned to me, I'd be more than happy to work with the district court judges in those districts to, if they've got a good idea, to say, hey, come on out and attend this meeting or that meeting. I think that's a wonderful idea.
Other questions?
I've got a couple.
How could
So
it be?
you've answered one of them already. You said you're from Hayes.
Right.
I'm from Dodge City. but I don't remember you. You probably went to Thomas More and stuff.
I did.
Okay. So you've answered that. Now, I graduated college in 79 and so did you.
Mhm.
I graduated law school in 82, but you graduated in 83.
I graduated undergrad early and worked as a newspaper reporter for a year.
I wanted to know what that lost year was all about. I
That
didn't
last
go to
year,
Europe.
so I have, and I do think, you know, while it's a long time ago and in the distant past, I was a journalism major. I worked 2 summers, first with the Ellis County Star and then with the Hayes Daily News. And then I worked in law school. I worked at the Omaha World Herald. I told them that I was going to be a lawyer, and they said, well, you know, we want somebody who's going to be here for more than a year. And I went across the river to the Council Bluffs Nonpareil and worked for a year covering school boards and city councils and those types of things, which I thought was just a tremendous entree into the world. So I was very pleased to have that opportunity, and I'm pleased that the Nonpareil gave me that experience back in 1979.
Yeah. Have you done, as part of your civil practice, any journalism related First Amendment?
I have not.
Rights? Yeah, okay. Of all your qualifications, which ones would you consider to be the most important for moving up from where you are now to being a justice of the Kansas Supreme Court?
You know, I think the ability to collaborate with others and to disagree without being disagreeable is probably the single thing that I would emphasize. I would hope that the years of experience and the understanding of the courtroom are things that would be right there with it. But I do believe that I do like to collaborate. I like to work with others. I want to get a consensus. And you know, I want to, I'm very comfortable, you know, in the situation of working with the district courts, working with the Court of Appeals. I'm very comfortable with that concept.
Very good. Thank you.
Sure. One more. One person described you as a community leader. Could you maybe elaborate on why that a person might describe you as such?
Well, I think that's probably eye of the beholder, but as I've indicated, I've been the partner in charge and kind of the face of Folston in Kansas City for a number of years. I'm not in that role anymore, but I believe that that's part of it. I believe the fact that I've been on the Economic Development Council in Overland Park, that I've been the chair of the chamber in Overland Park, that I have been active in the Kansas City Chamber. I believe I've been a president of the Kansas Association of Defense Counsel, where I served with Lawton Nuss and Evelyn Wilson, among others. And I believe all of those things are part of what others might consider, and I've enjoyed doing it. I do believe that we as lawyers have a responsibility to be part of the community and to give back. Active in my church, so I think those are all things that I would hope would be considered, and I've enjoyed doing all of that.
Anything else? Well, thank you.
Thank you for the opportunity for
I
this
believe-
conversation. Thank you so much for
Yeah.
doing this.
I believe you have some people with you. Would you like to introduce them to the commission?
Well, my wife, Mary Jane, we just celebrated our 44th anniversary over the weekend. She's probably mad at me for mentioning it, but you brought it. You know, I didn't bring Sabrina Thompson. She's the executive director of the Kansas Bar Association.
Oh,
She
okay.
used to work for us at Folston.
Okay.
And so I think she's here to observe and walked in. I really enjoyed working with Sabrina.
Well,
Thank you so much.
thank you so much.
Thank you.
Madam Chair.
Yes,
Should I make a motion? Are you ready for a motion
yes,
that we move into executive session?
that would be fine.
All right, at this time, I move that the commission recess into executive meeting to discuss financial and other confidential personal information of our candidates. And that is our justification for recessing into the executive meeting to protect the privacy of those candidates. I'd also request that our good clerk, Doug Schima, and Michelle Moore be allowed in the meeting as commission staff. We would then reconvene this room at approximately 4 o'clock, maybe
4:15?
4:15. Okay, 4:15 to continue an open meeting.
Is there a second to that motion?
Second.
All those in favor, say aye.
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 Gotta keep you on your toes, do it differently. Any objection? That being the case, we are going into executive session. We're gonna do that here, or are we gonna go next door?
Go next door, just.
Okay. Okay. We have a motion.
Yes, Madam Chair, I would move that we reconvene our meeting of the Supreme Court Nominating Commission.
Second?
Second. Okay, we have a motion and a second. All in favor, say aye.
Aye.
Opposed? None? All right, we will reconvene. Is there any other matters for us to deal with tonight?
Not that I'm aware of. I would make a motion that at this time we recess till tomorrow morning at 8:25.
Would we recess or adjourn?
Adjourn, sorry. That's the correct language.
I will second that.
Okay, all in favor?
Aye.
Aye.
Okay, we are adjourned until 8:25 tomorrow morning.
Thank you. Thank you.